Now, here's where it gets tricky for us to follow what they did. They used a process which on Wall Street is called selling forward. What that means is, if those of you who are familiar with the stock market, it's like short selling. It means you can sell something you don't have. So, right in the documentation, it says we've got this spreadsheet that has all these mortgages and notes, but they're not the real mortgages and notes. We're going to fill those in later. Now, a purchase agreement is executed between the special purpose vehicle and the aggregator who created the original pool that the mortgage and note was put into. Now, why am I going backwards here? Because this is the way it happened. First, they sell the security and get the money. Then they make a deal to buy the pool of assets. Then they go out and market to homeowners and get them to sign notes and mortgages and other documentation. And the way this is done is that the aggregator signs an agreement with originators of loans. So those would be the people who you thought, or you might think, were the actual lenders at closing, but weren't. They weren't using their own capital. They sign an agreement called an assignment and assumption agreement, which we're going to go over here in this segment. We're not going to go over every little aspect of it, but my point is that the assignment and assumption agreement, along with all the other deals I mentioned, the sale to the from the aggregator to the SPV, the sale of securities from the SPV to the investors, all took place before your mortgage ever came into existence. In fact, the assignment and assumption agreement in most cases precedes by date, sometimes as much as a year or more, your mortgage and note, which means that all of those deals existed before you even applied for a mortgage. The legal ramifications of that would be apparent to any specialist in contract law or property law. Suffice it to say for this segment now that at the time that the alleged closing took place, your loan was already sold, sealed, delivered, at least by the intent of the parties to the securitization scheme. It was already sold, sealed, and delivered to investors. It belonged to them the moment you signed the final papers. The interesting thing about that is, of course, that papers were signed by the so-called lender at closing and other parties after your closing. Those papers that were signed without any authorization. Why? Because it was the investors who already owned the loan. It was the investors who advanced the money for the pool from which your mortgage was funded. So let's take a look at an assignment and assumption agreement and see what kind of meat we can find in there that can be used in your defense or offense in challenging the mortgage or the note or the obligation in connection with your home. The assignment and assumption agreement usually contains a date right up at the front of it, whereas in this case, as you can see on screen, the date is February 27th, 2006, between Residential Funding Corporation, known as RFC in the rest of the document, and Residential Asset Mortgage Products, Inc. What's interesting about just that first paragraph is that these are parties whom the homeowner has never heard of until he sees this document and doesn't know what they have to do with his home, his mortgage, his note, his obligation. He has no idea because nobody told him, and they didn't tell him because they were intentionally withholding the information. Now, it recites that RFC has entered into seller contracts with the seller/services pursuant to which such seller services sell mortgage loans to RFC. So right here is an admission that you've got a securitized loan and that the sales of these loans have already taken place. Then you see that there is something called a master servicer, who is also a party that you probably never heard of. And then there's the actual servicer. And then you have the first point of confusion that occurs with many lawyers and many laymen. You'll see that J.P. Morgan Chase Bank, N.A., is the trustee. The question is, the trustee of what? If J.P. Morgan Bank is the trustee of the aggregate pool, then it is not the trustee necessarily of the pool that is included in the special purpose vehicle. Interestingly enough, each appointment of a trustee in the securitization chain usually includes verbiage that this trustee has succeeded to all the powers of any previous trustee, which might include, and I think does include, the trustee on a deed of trust in non-judicial states. So the trustees who initiate foreclosure proceedings in non-judicial states, under circumstances where the usual practice of an assignment and assumption agreement having been executed long before the closing, those trustees instantly, while named at closing, were denied any power to do anything from that point forward. Why? Because there are papers which purport to give powers to subsequent trustees. Now, there'll also be a trustee very often at the level of the special purpose vehicle.